Okay, great. So, hello everybody. My name is Brad, and I am your speaker for this afternoon. The topic that we're going to be speaking about is asset protection. I kind of changed it just a tad, Heather. I kind of made this asset protection and 7 trends in COVID business litigation, because that seems to be kind of like a top of mind. So we're certainly going to cover all the tools and techniques that you and I discussed offline about asset protection for an individual as well as a business owner. But I'm also getting a lot of calls from our clients. Our client base is a Vistage market, so they're all business owners. So what's some of the issues I have to worry about the tidal wave of litigation that's coming, or what are some of the things that we should be aware of? So I got a wonderful article here, which I'll share with you as a deliverable on the back end of the presentation, and I'll kind of just highlight the top 7 areas. I think it's an important discussion. So with that, I'm going to go ahead and share my screen so I can kind of get the slide presentation, and also, Heather, I'll be delivering to you the PowerPoint as part of deliverables as well. So if everyone would just kind of take some notes. And also, there's going to be a link. One of the things that we always do for our Vistage communities, and especially in a condensed 90-minute presentation like we're having today, it's going to be a lot. There's going to be a lot of questions. I'm sure there is. And so we typically always offer all of our Vistage members a 1 hour of free time to follow up with me regarding anything that we discuss here this afternoon. So whether it's an existing buy-sell agreement, corporate documents, a question, something that you have, something that a business partner has, any of these issues, you have an hour of free time. I'll promise you 2 things. One, I'm not going to sell you a book, and I'm not going to sell you a website. This truly is not a sales pitch, but what it is, it's really just a kind of a thank you, because I said Vistage has always been a very important part of my success, and I want to make sure that we always kind of give back a deliverable as far as some time to answer some questions, like I said, especially in this condensed format. And one last thing of housekeeping I wanted to address is, because I have everybody on mute, or I'm going to mute everybody, please put your comments in the chat. I have it up on my other screen over here. So I'll kind of, if a question pops up, I'll take a quick peek at it. If it's relevant for the moment, I'll get to it. If not, perhaps we'll have it on the back end. Heather and I did discuss, we'll have about 15 minutes or so, or however long you guys are available to go ahead and do some Q&A on the back end. Okay? Okay, great. So let me just go ahead, and as people kind of come in, we'll just kind of admit them. Okay, so I'm going to go ahead and share the screen, and here we go. So here we have asset protection and 7 trends in COVID business litigation. I kind of like the subtitle more, which is really protecting your wealth from creditors, predators, liens, and judgment holders. It all just depends on what the source of those creditors or predators are. As already mentioned, my name is Brad Barth. I've been working with my father, who started Barth Calderon. I'm with him since 1997. So this is my 22nd year of practice with my dad in this particular area. My 2 key areas of practice are in the asset protection area, which we'll be speaking about today, both domestic as well as offshore asset protection planning, as well as estate planning, business succession planning, real property transactions, charitable planning as well. So I'm also the supervising attorney. I have, I think, 12 attorneys underneath me as part of our nice mid-sized law firm. And so it's kind of, it's nice to have grown up over the years in the firm. And so I kind of enjoy the status of a junior partner. My dad didn't see to go Barth, and Calderon, because I actually have a couple of other Barths. I got my mom, it could be Barth, and Calderon. So I think for nepotism purposes, we decided to keep it just one Barth. So a little background about the firm. We're located in Orange, California, and there's my contact information as well. Okay, so quickly, just from an agenda, let's talk first of all about definitions. What is asset protection? I think it's very important that you always start off with a clear definition of what we're talking about here. And really what it is, it's a process of separating assets from liabilities. And you can call this a little process of separating assets by using other legally accepted concepts. And we have things like business planning tools, tax planning tools, education planning tools, retirement planning, insurance planning. There's all kinds of different tools that we use to basically create barriers between assets and liabilities. A lot of us online here are already engaged in some form of asset protection. I have to assume everyone has some form of insurance, whether it's auto insurance, commercial liability, EPLI, umbrella insurance. So you've already taken some steps to mitigate your potential liabilities from other sources, or you already are an LLC, a corporation, a limited partnership. So you've already engaged in some form of asset protection, here again, to limit the liability. And so what we're going to do is we're going to kind of break them down as to what are some of the benefits and what are some of the deficiencies and how do we cure that. This presentation is given in a, we'll call it a problem solution format. We're going to be, I'll be introducing you to our hypothetical client, Hank and Wendy, which simply just stands for husband and wife. And Hank and Wendy are going to have some assets, and Hank and Wendy are going to have some liabilities, and we're going to see how the asset protection tools make a difference in their ultimate outcome. It kind of helps me have it in a narrative format. So hopefully at the end of the 90-minute presentation, you'll be able to kind of see how it all fits together. And if time allows, I will be putting together an overall structural map here again to kind of show you how it all fits together as well, so you can actually see it visually. I'm a visual learner, a visual thinker, so if I'm able to see things, I'm able to get it not so much on an individual basis, but kind of how all the pieces fit together. And so this is my definition I put down here in yellow. The more barriers between assets and liabilities, the greater the leverage you have to negotiate a fast and favorable settlement with the creditors. To me, that's what asset protection is about. It's not about making you lawsuit proof. It's about allowing you to get out of litigation quicker and more favorably as a result of the planning tools than you would have been without the planning tools. It's all about leverage, because there's cost, there's time, there's inconvenience in going after somebody's assets. We want to make it difficult, challenging, expensive, time-consuming for someone to go after your stuff. Therefore, you're much more likely to enter into a favorable settlement and maybe make it on the insurance and then kind of move on. So I think that's actually a more accurate description of what asset protection is all about. And like anything, we always have to have a quick little assessment of what the assets are. So one of the things that Paul has put together, Paul is our Director of Business Development, and I'll be sharing with you afterwards, is a link to kind of help us for our initial consultation. What are the assets? If we're going to have a productive conversation on the back end, what are the assets? What are your potential liabilities? What are you worried about? And so from that information, we're able to come up with some type of plan that maybe you can implement straight away. So we have to take a look at the assets. We have to look at what the threats are, but you also have to know what assets are vulnerable, because one of the great things about Florida is that you got great built-in exemptions. There are a lot of very powerful tools that are already readily available for you. So some of your assets may not have vulnerabilities as by comparison what we have here in California or some other states. So it's important for us to identify where that risk is, because that's where we'll be focusing our time on that assessment. Okay, so this is also another important housekeeping item. Is it ever too late to do asset protection? Get this question all the time. Brad, I heard you in your Vistage presentation, you talked about the guy that hit the motorcyclist and blah, blah, blah. Well, guess what? I'm calling you because I hit the motorcycle. Fill in the blank. And so it's important, like any other type of insurance, you need to have these tools in place before the need arises. So think of it as a medical insurance or life insurance or fire insurance, the picture I have on the screen. You can't have your house on fire, God forbid, and then you call your insurance agent and say, oh, by the way, I need to buy some fire insurance. Too late. The incident already arose. And any kind of asset protection planning kind of falls into that category as well. So you in Florida have the top line called Uniform Fraudulent Transfers Act. Other states like us in California, Voidable Transactions Act. Every state has some version of the big bold red line, no after the fact transfers. If you have the car accident on Monday, you can't then transfer your assets on a Wednesday, right? Accident on Monday, transfers on Wednesday. Because that transfer on Wednesday is going to get scrutinized by the court. Why'd you do it? Why now? And if you don't have any legitimate reason for that transfer other than an attempt to hinder, delay, or somehow defeat the creditor's claim, well, there's a remedy. Let's just say you're not the first person to come along and try to do this. There's a remedy called a fraudulent transfer. And what happens is the court sets aside the transfer. They legally set aside as if it never happened, putting you back in possession of those assets and then the creditor can take it away from you. So you can't have the event and then do the planning. You need to have the planning in place. Just like I started off, I assume every one of you has insurance in anticipation of. Every one of you is already an LLC or a corporation in anticipation of. You're not waiting until your company gets sued. Now you form the corporation. You know better than that. And what we're going to be talking about is exactly the same. So asset protection planning is a form of legal risk insurance. When negotiations fail, when insurances fail or deficient, you're falling back on the legal structures to go ahead and keep that level of separation between the business liabilities and your personal assets. Okay, so it's very, very important to understand that there is a legit timeline going on here. So the tools that we look for here are liability insurance planning, kind of mentioned that, exemptions, very important for you guys in Florida, concurrent ownership if you have it with more than one person, marital assets, business entities, we already kind of mentioned a handful of them. Debt as a very powerful asset protection tool, retirement assets, estate planning tools, and business planning tools, much like buy-sell agreements and stock purchase agreements. How can we use all of these? I don't have a specific slide or hypothetical on the use of debt, but it's always a very important thing to start off with because it kind of gets you in the mindset of what we're talking about here. If you have an asset, and we'll just call it a piece of property, not your residence, because you guys have a wonderful homestead exemption. Let's just say you have another piece of property. It's a second home, or it's a rental property, or it's a commercial building that you're occupying. And let's, again, hypothetically, it's worth $1 million. I'm doing lawyer math here. It gets $1 million, and it's got no debt. Okay, again, just lawyer math. So if you have $1 million asset with no debt, that means you have $1 million in equity. So now you have a liability. Now you have a $1 million asset that now becomes very attractive for a sheriff to levy on and then to go ahead and foreclose on, and they can take those funds and use it for the benefit of your creditors. So because it's got no debt on it. But if we took that exact same asset, that same exact $1 million building, and we put a first on it, maybe there's a second, maybe even a third. In other words, what we're doing, we're sucking up the equity by putting other encumbrances on it. Now we have $1 million building, and let's just say it's got $900,000 of encumbrances on it. Now that exact same building went from a very attractive asset to a very unattractive asset. Because when plaintiff lawyers are suing you and they're looking to see, are you worth suing? They're not just looking to sue you for sport. They're hoping to be able to collect on the back end. So if you have assets that have perfected encumbrances on them, now all of a sudden you turned an attractive asset to an unattractive asset. And why is this important to business owners? Because I can tell you that I'm sure every one of you online here has put money into the business. We business owners, we all do. We cover payroll, we cover equipment, we cover whatever the case may be. So the question is, if you put in $300,000, did you take a promissory note back? And if you took a promissory note back, did you go one step further and perfect that against the building or against the equipment or against the ARs or against the inventory? Because if you would have gone to Bank of America or Wells Fargo or any other business bank to get a business line of credit, they certainly would have taken a first or second position on your building. They certainly would have filed the UCC1 against your inventory and receivables and et cetera, because they want to be in the position that if there's a default, they get paid back first. So very much like us as business owners, if we're going to be extending credit to our company, let's make sure that if there's a liability, we get paid back first. And so what it's effectively doing is sucking up that equity corridor and giving all those and putting us in a more favorable position against the creditor. So you take that idea of using debt and you apply it strategically over assets and over time. Now you have a very powerful asset protection tool. Again, you went from an attractive asset to an unattractive asset. And that's just one example of kind of some of the very basic tools that we use and where there's room for improvement. Well, just like we have to know what the assets are, we have to know what the creditors are. So this is a very pedestrian list of creditors that we have: business partner liabilities, employee liabilities, divorce. People seem to forget that a divorced spouse can be a very challenging creditor to deal with because many times those negotiations are being driven by emotion and not being driven by dollars and cents. And it can be very difficult to negotiate with such a creditor. Personal guarantees or corporate guarantees, taxes, again, another very challenging creditor to deal with. Because when you're looking at taxes, I mean, the government will spend $1 million to collect 100,000, right? It has nothing to do at all with what are they going to get on the back end. It has everything to do with enforceability of their regulations. So again, who the creditor is, depends upon what type of tools that we use. Professional malpractice, rental property, sexual harassment violations, auto accidents, again, getting into the pedestrian stuff, homeowner accidents, family members driving our car, medical bills, deficiency judgments is a big deal. And now we have a new player here, COVID-19 and PPP matters. And this kind of brings me into the 7 trends of COVID litigation targeting business practices. And this is just the articles I strongly recommend that you read. I was surfing around a few weeks ago about stuff, and this is a very good condensed article, and I'll send it over to you. And it basically comes down like this. You know, you got failing to provide safe environment for employees and customers. That's the most obvious one. And what's the challenge here is that it gives rise to what I've been calling the invisible boogeyman, because it's always about the deep pockets, right? So you may be out, or one of your employees may be out at a party someplace on a Saturday, or you're at the beach, or whatever the case may be, and they contract COVID there. But the beach doesn't have deep pockets, but you do as the business owner. So what are they going to say? I got it because I was pushing the button at the elevator, or it was the handrail coming up, or the keyboard, or the phone system. So you just don't know what the source of it is. And so you're automatically, as a high net worth individual or as a business owner, on the defensive as to what to do about this. And this exact same thing applies to my people who own property, rental properties, apartment buildings. You got common areas, right? You got, again, handrails, elevators. The guy next door is coughing, and you call the landlord. Landlord does nothing about it. What are your protocols for sanitation? And again, it goes back to that invisible boogeyman. Ultimately, it puts us on the defensive. So you got improper conduct in advertising and pricing. You saw this a couple of months ago with price gouging, and you're getting false advertising, and you got the government coming after you. Product advertising. This is COVID gel. It's not. It didn't have the appropriate amount of alcohol in it, and those things. This is a big one. Number 3, using COVID as a basis not to perform. Right, you got these things called force majeure. You got impossibility of performance. So what happens there? And you now are basically breaching your contracts, and you're going to rely on, hey, I can't do it because of COVID. The state shut us down. I can't have any customers. How am I supposed to perform? You have all kinds of issues that are coming up from there. And as far as you're using it as a defense of impossibility, and they're using it as a defense to force it. You have to buy the building. Why? I no longer have the employees. My business is no longer viable. I was already engaged in contract. You got people forcing to go forward with it, and you got people trying to get out of it. Again, very, very big deal. A statement regarding investors, impacts and risks. You kind of saw this with, I think there was some of the, COVID testing things. I even saw it on the Zoom platform. I believe there were some issues with the stock price going up because of their security issues. I know as a big Zoom user myself, I've been getting a lot of almost weekly updates. So we've done this for security. We've done this for security, because we're trying to appease their shareholders, because there certain industries cannot use the platform because of the breaches in security, and it's causing a fluctuation in the price. Collecting fees despite not providing services, providing refunds or cancel events. That's a big deal. I got Ducks tickets to the hockey team over here. What about that? I had an airplane ticket going somewhere. So, well, here's a voucher. I don't want a voucher. I want my money back. So you have all these types of challenges as well, as far as people taking money, holding it in trust, and not being able to deliver services. We saw it with gym memberships. They got it with auto insurance companies. Are trying to get ahead of it by giving you a discount in advance. So these are all the things, even Disneyland, we're local. You guys, you're local as far as Disney World, we're local in Disneyland. We were annual pass holder. They stopped debiting my credit card on our passes because they're taking money and the park's closed. So they came around, there were some lawsuits regarding that. And the last thing is just inequitable conduct under government relief programs, as far as the necessary need for the PPP applications. I'm not going to spend too much time on this because this is just as of June 16. This is the latest stuff that I had just a couple of weeks already, and this stuff is just such a moving target, and it could be such a rabbit hole. But I think the important thing to note is that President Trump did sign the PPP Flexibility Act on 2020 on June 5, and it changed the 75% used towards employee payroll to 60%, had to be spent within 8 weeks, now extended to 24 weeks. It's not all, it can be pro rata on your forgiveness. What if you don't use the funds? It was a 2-year payback at 1% for the deficiency with a 6-month stay. Now they bumped it out to 5 years and kept the 1%. What if you got the note, the PPP loan before June 5, now after June 5? So this is itself, as no surprise, it's kind of a disaster. So I think the most important thing you can do is kind of keep detailed records, and there's a general presumption that anybody that had loans of less than $2 million, you're kind of good. But if you had loans more than $2 million, you better take a very good look at your need for necessity on the need for those loans. This is an article, Heather, which I'll also send over to you. It's dated, it's May 17, but it's a great 6 or 7 page recap of the history of where it was, where it's going, and also some of the things that the government is doing to kind of enforce the terms of the PPP, and what we as business owners need to be aware of for forgiveness and proper documentation and record keeping. So between this article and some of the stuff you're seeing nowadays, Forbes.com has been a great resource for myself in looking these things up. So that's another area I think that'd be worth taking a look at, because again, this is relevant to all of us as business owners as far as the ongoing liabilities as a result of taking out this PPP loan. So getting back to the substance of the presentation, so one of the things that we have to work on is always trying to find the proper balance in our planning, right? What's the asset, like our castle back here? What's the asset that's sought to be protected? Who are the potential creditors coming after it? And once we understand that, we now know what type of defenses we have to come up with to protect those assets. And then this is probably, in my opinion, the most important slide in the entire deck, which is basically what asset protection is and what it's not. It's designed to deter litigation and promote settlement. As I already mentioned, it's not about not being sued. The idea is that if you are sued, how do you get out of this as quickly as possible? Understand that there's 2 different phases of litigation, that there's the liability phase, and then there's the collection phase. We don't engage so much in the liability phase. Like, did you run the red light? Okay, that's a matter of fact. Did you run the red light? That's the question. Did you run the red light? If the answer is yes, okay, now that you ran the red light, what do you have that we can take away from you to satisfy the judgment? Now is where we kind of come into play. It's not protect me from getting sued for running the red light. Can't do that. You ran the red light and you're found liable. Now the question is, what do you have that we can take away? And that's, again, what asset protection is about deterring litigation and promoting settlement through these various tools. So let's get into our clients, and you can start seeing some of this stuff in action. So here they are, Hank and Wendy, okay, Hank and Wendy. And here is their, and let's talk real quickly about what their assets are. So we have to have some assets and we have to have some liabilities. So they have a residence held in trust. That's their revocable living trust. That's kind of how it's held. $1 million paid in full. They have a Burger King corporation. It's an S corporation, 2.5. That includes the operations and the underlying land, $2.5 million. They have an apartment building, $2 million held inside their family trust, RLT. They have a townhouse also held in trust, $800,000. They have some stocks, bonds, and cash, right? They have $1.45 million in cash or other forms of instruments also held in their trust. Did a great job with their estate planning lawyer. Everything is where it's supposed to be. And they have a couple of ERISA qualified plans. Hank's, we'll call it the Boeing 401k, and her 403b, she is a school teacher, $350,000. So we have some assets. Well, we got to have some liabilities to kind of get our narrative going. And then we have a car accident, and we have a dog bite. Car accident was done by Hank, and we have a dog bite. Who's their dog? Let's call him Killer. He's a half pit bull and half Rottweiler. Okay, and his name is Killer. So that's kind of our liabilities. So now let's take a look and see how So we have our liability. The question is now what happens? So the first line of defense that we come up with, first line of defense, is going to be our insurance policies and our exempt assets. And this is great for you guys in Florida. Insurance, of course, is what you should think about. Well, I had a dog bite, it should be my homeowner's policy. I had a car accident, that should be my auto insurance policy. Let's take a look and see how that plays out. So insurances come in all kinds of flavors and shapes and sizes. You got auto, umbrella, commercial liability, EPLI, malpractice, E&O, and D&O. And so many times I get pushback when I'm talking about asset protection. People say, "Oh, Brad, that's all great, but I have a $6 million or $10 million umbrella policy." I say, "Great." I say, "Well, the next question I typically ask is, have you seen the policy?" I don't even ask if you've read it, because I know the answer to that question. The question is, have you seen it? And yeah, I've seen it. So it's about 30 to 50 pages. It's double-sided, dual column, 6-point font, and basically page 1, paragraph 1 says that you're covered for the following events. And the remaining 30 or 40 pages are things that you're not covered for. They're called exclusions. And this is what always shocks me, is that if people are going to rely strictly on the integrity of the insurance policy as their main asset protection tool for everything that they've worked so hard for, their business's well-being, their family's well-being, their employees' well-being, they should do themselves a favor and at least read it, because there could be exclusions in there that are absolutely applicable to what you're doing. And an exclusion is exactly that. It's excluded from coverage. And I always use one little simple example that I give. When I was in college, I delivered pizza for Domino's. And I did this for 5 years. This was back in the day when they had 30-minute guaranteed delivery. And thank God I never had a problem, never had an accident. But every quarter I was obligated as a driver to turn in a copy of my license and proof of insurance. And I always did, no problem. Fast forward a handful of years, I become a lawyer and I'm telling my clients to review their auto policies for exclusions. I said, well, I should do the same. And I have the same policy that I have back in the college days. And what does it say right there on like the first line of exclusion in my auto policy? Use of car for business or commercial purposes. But it went one step further. It even says, for example, pizza delivery. Kid you not. And so this is an example where I had a false sense of security that I was covered when in fact I wasn't covered. And not only did I have that false sense of security, whose car am I driving in college? I'm driving my parents' car. They had a false sense of security as well, that I would be covered. And you see this now in the world of Uber. You see it now where we have our employees run to the bank for me. Or can you bring, now I'm working from home. I have my secretary once or twice a week or 3 times a week bringing mail to me at the house. Are they covered? And so this is an issue to take a look at in this new environment. Other thing we have to worry about insurance is, well, what about insufficiencies of coverages? Well, I got $5 million of commercial liability. Well, the example I'm working with right now with the client is I got $12 million of liability. There was a fire and 3 people died. Mom died, baby died, and the little girl died. Husband and son survived the fire. Well, my client has a lawsuit now for $12 million of wrongful death. But I also have a statement from State Farm saying, we're going to cover you, full policy limits, $3 million. Great. So you got $3 million of coverage. I have a $12 million liability. What's that deficiency? $9 million. It doesn't just go away, man. It's still there. And the client coincidentally is worth about $8.5 million. And all the assets are in their name. It's a very difficult situation to deal with. And insurances lastly are limited in time and scope. And I say time and scope because time is only when you're covered. There's actually a very typical time stamp, not just the date stamp of coverage, but a time stamp of coverage. And one of the first things I do, my pen, sparks come out of my pen when I sign the check to write for my insurance policies. I want to make sure that I'm always covered. If there's ever a gap in coverage, I'm like freaking out. I want that to be, I'm worried about time. And scope, we just got done talking about exclusions. If it's not covered in scope, it's not covered. So if you have limitations, I call it spatial and temporal limitations, you got to then fall back on plan B. That's the legal structure. Insurance failed. What's the next structure that keeps it from getting to me personally? And that's what we're going to talk about. So absolutely, insurance is important, but insurance by itself is not an asset protection plan. It's just one of the tools that we use. Now, very important for you guys to know what's with the exemptions. And I put O.J. Simpson on here because he put this on the map and it's directly relevant to you guys in Florida. So basically, how do they work? It's very simple. If somebody is wiped out in bankruptcy or completely wiped out as a result of a lawsuit, we don't want them to become a ward of the state. You're completely wiped out. You don't have enough two nickels to rub together to get a fresh start. And then you become everybody's problem. Well, nobody wants that. And so every state has some public policy that says you can keep a certain amount of your stuff. And those are called exempt assets. And so here, what we look to do in a wonderful state like Florida, can we convert non-exempt assets to exempt assets? So what are examples of the exempt assets? Homestead, absolutely your homestead. ERISA qualified plans, 401ks, IRAs, 403bs. Florida doesn't care, man. If it's retirement, if it's tax deferred, it's protected. As this to give you some comparison, in California, my 401k plan is protected, but my IRA is not because they're different statuses. But in Florida, both protected. Cash value of life insurance, great, Florida protected. California, not above $9,700 in cash value. So this to kind of let you see how wonderful it is to take advantage of these things. Annuities in Florida, 529 plans in Florida, great, excellent. So we look to, can I convert? What's not on that list, by the way? Cash, right? So our clients, Hank and Wendy, are cash at $1.4 million. They get sued. What do I do with the cash? Well, if they did before they got sued, let's say you have a house that's worth $1 million and you got $750,000 of debt on it. So your corridor is only $250,000 of equity. But I have $750,000 of cash. So what happens if I take my unprotected cash at $750,000 and I pay off my mortgage at $750,000, now leave me this nice, complete $1 million homestead exemption, completely protected, not by Florida statutes, but by Florida's Constitution. Now I have a completely protected asset, the strongest protection in the country, Florida's homesteaded. So this was an example of converting non-exempt to exempt, but you got to be careful. You got to watch out for what's called a fraudulent conversion. We already talked about fraudulent transfers on moving assets. Can't do it after the fact. And the same thing applies to exemptions. You can't have the accident on Monday and then pay down your mortgage 100% on Wednesday, because now you have a fraudulent conversion. But we can maximize the homestead exemption. You can put money into your 401k plan. So just for example, just because you get sued doesn't mean that you can't take advantage of these things, because remember, life goes on. When someone sues you, they still have the burden of proof. And the wheels of justice, especially in this COVID backlog environment, wheels of justice turn slowly. So what happens during this time period? You mean someone sues you for any reason, for whatever, you're not liable, they just sued you. That means what? I can't put money into my 401k plan. I can't put money away for my retirement. I can't pay down my mortgages because I'm concerned about my retirement income needs. I can't put money into my kids' 529 plans. Are you kidding me? So I can't buy life insurance as part of the survivorship needs for my family or my charitable considerations. So all of these things are still available, but you better be able to answer the question when it gets scrutinized. This is why you need to do these things with advisements, right? And how these things move forward. It doesn't mean that all of a sudden you get sued, you can't do anything. You now become a guarantor of your assets for your creditors. No way. But what you can do is you can do things that stand on their own fours as part of an overall financial plan. So you can respond back. And if you don't take advantage of those wonderful exemptions in Florida, you really are losing a wonderful opportunity. So it's very important that you pay attention to what these are. Okay, so we have our debtors examination. So you can see I put in green here. So here we have what's the result of our first line of defense in my debtors exam. So Hank and Wendy were found liable. We now go to our debtors examination. The first thing we talked about was our insurance. They had a 100, 300 auto insurance policy and a $2 million umbrella. So we were able to net out 2.1 million off the 3.5 liability, if you remember from the facts, which left a deficiency of 1.4. They still owe that. And what about the dog accident that resulted in the $115,000 dog bite? Well, excluded from the homeowner's policy. Exclusions. Why? What type of dog did I say he was? He was a half pit bull, half, I don't know, German Shepherd. Name is Killer, right? He's a chainsaw with 4 legs. And as a result, he's a bad dog. And so there is an exclusion in most homeowners policies for what's called the bad dog list. Legally, we call them dogs with known dangerous propensities, which means that they're excluded and now you own that liability. So if you have a dog that's half pit bull and half Rottweiler, go ahead and call your State Farm or call your homeowner's agent and say, is there a bad dog and can I purchase a rider for him or her? So in case they do bite somebody, at least you're covered for that one event. But that wasn't the case in Hank and Wendy. That's an example of a deficiency up on top, an exclusion under the insurance's first line, which leaves a deficiency of 1.5. But now let's look over at our exempt asset side. ERISA qualified plan safe, right? I just told you it's safe, $350,000. Florida's got some wonderful stuff on a state versus federal law. And then you got your homestead, even though it's in your revocable trust, still protected. Homestead, Florida protection. So in our case, our first line of defense for Hank and Wendy did a pretty darn good job. Now, let's take a look at the next level. Let's level it up a little bit. We're going to go now to our battlefield strategies. So now we're going to take a look at trusts and legal entities. And so let's kind of go back to Hank and Wendy. Let's also increase some of our liabilities. So we already got away with our insurance, our residence. We already got away with our retirement plans. But now we have a Burger King had a hurt customer. And again, these are all real facts I'm giving you and real dollar values. So in this particular case, a customer sat down to eat the hamburger at Burger King. The employees, as a joke, undid the screws on the chair. And when the customer sat down, they fell down and they broke their, they fractured their back and had some other issues happening with them, and resulted in a liability of $875,000. Now, I like this example because it's not about insurances. This was an intentional act of an employee. Typically, not intentional acts are not covered by commercial liability policies. It covers things like negligent hiring and negligent supervision and negligence, but this was an intentional act. So as a result, I use this because it gets me out from under the, what about the insurance argument? I just want to make sure we have $875 of ongoing liability. And if you remember, the Burger King is an S corporation. So let's first take a look at trusts and entities. And I first also want to talk about trusts, because before we get to the entity discussion, which will take more time, I want to address the trust question, because I get this all the time too. Brad, I don't need any kind of asset protection. Everything's in my trust. And I said that Hank's and Wendy's estate plan lawyer did a good job. They put their apartment building in trust, their residence in trust, their townhouse in trust, their brokerage accounts in trust, all in trust. And they're walking away with a false sense of security that everything is protected. And what I say is that you're confusing the term asset protection with probate protection, or asset protection with minimizing expenses protection. But it's not asset protection, because if you look at how trusts are designed, and this is for a typical estate planning trust. There are other forms of trust, but I'm talking about a typical estate planning. You hear wills and trusts and powers of attorney. Typically, the trust maker would be Hank and Wendy. The trustees, the owner and manager of the assets, Hank and Wendy. Hank and Wendy retain the power to revoke it and modify it, hence a revocable living trust. Hank and Wendy are my lifetime beneficiaries. No separate identification number, no separate tax return. They have to get no one's permission to go to the bank and take out money at the ATM machine. They are the lifetime beneficiaries. They have the power to put assets in. They have the power to take assets out. In other words, you exercise so much dominion and control over your family trust that it's really no different than you personally. So I sue you, I get your trust. I sue the trust, I get you. So this is the importance of this particular slide. So in a case like this, If you have an apartment building, a townhouse, and cash all held in trust, again, no protection. So this would fail our battlefield strategies. We're going to come back and address this. I said problem solution, but I want to make sure that at least we talked about it on the front end. On the back end here, we're talking now about entities. And so here, entities for most of my clients, they have either corporations or LLCs for operating businesses. And so I call this internal protection. And so I also put the C versus S in red, because that's how the corporation is taxed. It's not that there's no such thing as a C corporation and then a different S corporation. They're both legal corporations. How you elected to tax it with your tax professional will determine if it's taxed as a C or an S, an 1120 or 1120S. Is it taxed as its own entity? Or is there a small business election that has conduit flow through, netting out some of the expenses? That's an S. That's tax issues, but legally it's a corporation. It's not like C corporations are more powerful than S corporations. It's important. I want to demystify that because that comes across a lot. So what happens here is that you put the assets inside the corporation. So in this case, it's like my Burger King. Well, I told you that Hank and Wendy had a Burger King. The improvements, the operations, and the land was inside the corporation. So here's my operations and here's my land. And what happened? Slip and fall, pulling the chair out, $875,000 of liability. Well, I lost my operations. But if that wasn't sufficient, remember, we're not talking about insurance. If that wasn't sufficient, because in reality, what's a Burger King going to go for? I mean, it's like salvage. I mean, it's like auction value for the playground and the used fryer, you know? So now you have a deficiency. And if there's a deficiency, well, what else can the creditor go after? Everything else that's inside the corporation. And I get this all the time. Brad, don't need asset protection. Everything's in my corporation. I said, oh yeah? Well, tell me about your corporation. What's in there? Well, I got my land. I got my accounts receivable. I have my cash reserves. I have my tenant improvements. I have my IP. I have all my assets are inside there. Oh, what else is inside there? Oh, I got my employees, all my contract obligations, my sexually harassing supervisors, my drivers in the trucks and cars, my chemical spills and toxic waste is all inside. So what you've done is you've mixed all of your assets and liabilities on the inside. And so an example here, a slip and fall on the property, a a defect, a bad hamburger, someone getting injured, an employee a COVID problem, and guess what? You lost your building. Because now, sure, you don't have any liability because the corporation limited your liability, but you lost the entire enterprise. Because the person that was asked, this is again, I'm making an assumption, the person who was asked, hey, I'm about to buy a building. How should I take title, Mr. and Mrs. CPA? Oh, take it inside your corporation. We'll get the deduction. So what they did is they're letting the tax tail wag the legal dog. They didn't diversify the holdings. They put in the assets along with all the risk. I call it the hot assets are in with the cold assets. Bad idea for planning. Sure, you limited your personal liability. Sure, you improved your tax position, but you certainly didn't limit your liability from the asset perspective. And if this wasn't sufficient enough, like now you took the building out, you took the operations, and you're sitting here, okay, I have no personal liability. But wait a second. You got the plaintiff's lawyer in there that says, wait, I have a 30 or 40% economic incentive. I know Hank and Wendy, based upon what I see in the public records, they got a nice house, they got some bank accounts and whatever. I know that if I can pierce that corporate veil, I'm going to get Hank's assets personally. And you've all heard this. It's called piercing the corporate veil. And how do you do it? It's very simple. You simply are not acting like a duck. You're not quacking like a duck. So don't call yourself a duck. And it has to do in the corporate world. And I see this all the time. The company gets sued. The first thing they ask you for, can I have a copy of your corporate books? Sure. Here's my corporate kit. And the first thing you have to do is go like this. Get all the dust off of it because you haven't opened the darn thing in 10 years. And then I kid you not, when you open it up, the documentation is still in the cellophane wrapper that LegalZoom mailed it to you in. You haven't even signed your bylaws. You never issued your certificates. And every time you're corresponding with your clients or customers, hey, thanks for the business, Bob. Not thanks for the business, Bob, president of Bobco, right? You're not, there's confusion in the marketplace now how you're holding yourself out. An EIN number and a bank account does not make a corporation. You have certain formalities that must be respected in order for that corporate veil to offer you protection. So if you're not respecting the corporate formalities, don't expect your creditors to respect it either, or the judge. And I'm telling you, you have to work hard for this to happen. Judges don't like piercing corporate veils left and right, but they will if you're not respecting it yourself, and also how egregious the facts are. They're human beings also. And then if that isn't bad enough, now you have a thing called a reverse piercing. So we talked about taking the corporate liabilities and going after the shareholder. What about the shareholders' purse? Because that's what we are. We own our businesses. What about our shareholders being able to pop up and grab the corporate assets? It's called reverse piercing. And here again, courts generally discourage this. However, it does actually occur. And it's happened in Florida. A couple of big cases here. The Broswell versus Ryan Investments is one that kind of popped out on doing my research here. Outside reverse corporate veil piercing, bottom line is like this. Corporation's veil will be pierced where the corporation's controlling shareholders formed or has used the corporation to defraud creditors by evading liability for pre-existing obligations. Okay, that's basically, you form a corporation as a shell and you're doing all kinds of bad things, right? For whatever reason. We're all aware of that. But here, it actually works in reverse. The usual, here we go. The remedy is equally available, however, to hold the corporation liable for the debts of the controlling shareholders. Now, here's the kicker about this case. Where the shareholders have formed or used the corporation to secret assets and thereby avoid pre-existing personal liabilities. So if your corporation exists already, then great. It seems like it's going to be protected. Florida doesn't like doing reverse veil piercing. But if you do something and have a creditor and then form a corporation trying to move the assets, this is basically saying what I told you earlier, there'll be a set aside. The court will disregard it and allow them to reach in and grab those corporate assets anyway. Okay, so it's just kind of another way. And every state, one of the benefits of being a visitor speaker is I get to research all the different states' laws about this, and everyone's a little different. Sometimes they let you grab the asset and foreclose on the asset, but here Florida does have some limitations. Again, I think it's very good. Florida is a wonderful state for business owners and high net worth individuals. But this is what it looks like on a personal side. So you have a liability, they go over and grab your stock, and then they use that stock and to put themselves on as the president. They vote the stock. The shareholders vote the board of directors. The board of directors appoint the officers, the president and vice president. They put themselves on as president, and then they liquidate the company from the outside in. Now, I don't know exactly what what we called shepherdizing the cases in Florida, how this would actually pan out, but I can tell you that we don't even want that to be a threat against us, right? You threaten a business owner with one of two assets and they scream uncle. The first one is you threaten them with losing their house. Unlikely with you guys in Florida. You got a great homestead protection. The second thing is you threaten them with losing their business, okay? And then there again, that's where their entire blood, sweat, equity, their soul is in that company. You threaten them with losing their business. Here again, you may be put into a disadvantaged negotiating position. We want you negotiating from strength. We don't want them to be able to take that away from you. And so this reverse piercing is a big deal. I was giving a talk in New York a couple of years ago, and I kind of did the similar type of reverse piercing. And I love this statement. I was like, what are the big Manhattan lawyers telling their other colleagues about what to do about reverse piercing? And here's their bottom line. Nowhere to run and nowhere to hide. Catching and collecting from debtors with reverse veil piercing. This is kind of just gives you the idea. And here's the bottom line advice. Reverse veil piercing can be a powerful tool in your arsenal of post-judgment remedies. Sometimes simply the threat, and I've seen this, simply the threat of a reverse piercing action is enough to bring a reluctant debtor to the negotiating table. So that's basically what it is. We want to make sure that those assets you aren't vulnerable based upon how you're holding those assets. And we do have remedies to put you in that, to change that overall position. So here's a cool little slide that kind of shows you what piercing and reverse piercing. So you pierce the corporate veil when you have a judgment creditors going after the business, business has no money. And that could also mean that you're running an insolvent business. And I could say you could have a fully functioning company, but you don't have enough money for its ordinary operations and obligations. I call your O's and O's. If you don't have enough, if you're not solvent, every single thing the corporation does is basically an alter ego issue. You're basically an insolvent company, which means everything you're doing in the company veil is a personal liability. You're an insolvent. You don't have enough for your O's and O's. So now they would just go take the company assets and company liabilities and go after you personally. That's the reverse piercing. I'm sorry, the piercing. This is the reverse piercing where they're coming after you, the individual, and you got no money. But hey, but you own a Burger King or you own some other company that does produce a lot of money or has a lot of assets. It's got businesses, it's got cash reserves, it's got IP. Can I grab that business and pop in and now start taking the assets? That's what reverse piercing is all about. Florida seems to not like reverse piercing, but again, I want to at least bring it to your attention. It's one of those things that we deal with quite routinely. So in a case like this, going back to our debtors examination, they lost the land, right? Because they were basically the fall off the chair happened in Burger King. It was an internal creditor. The land was inside there. That little Tasmanian devil ran around and grabbed all the assets. So they have no operations and they have no land, and now they're on the curb burping and chirping with no income. So they basically lost that. So now let's take a look at how an LLC would make a difference, because this is one of the main tools that we use, LLCs. LLCs is the basic building block of any kind of asset protection structure. So what is it and how do they differ from corporations? Well, structurally, they look the same. Again, from an internal point of view, that is here, the same exact scenario. If the Burger King would have been an LLC and you had to fall off the chair, wasn't enough, they went after the building, no difference. Internally, no difference whatsoever. The difference all apply on the outside, okay? So it does offer you internal liability. By the way, LLCs can be taxed as a disregarded entity, meaning they don't exist for tax purposes. Two people, they can be taxed as a partnership, where you get a 1065 in K1s. They can be taxed as an S corporation, so they'll have a small business election. You're an LLC, but you file an 1120S. You basically have an S election. Or you can even elect to be taxed as a corporation, a C Corp. You can have LLC taxed as a C. So I call LLCs the Swiss Army knife of entities. It can practically do anything, hold anything, and can be taxed any way you want. So it's a wonderful tool, and it becomes the basic building block, and it's a lot more protective than our corporations. Not from an internal problem, that's the same, but from an external problem. So how do we first solve this issue with them owning the land inside the same place as the operations? Like I said, the hot asset and the cold asset. I would say if one LLC is good, two is better, right? And so here you have the exact same scenario. Now you have operations happening over here. Forget LLC, leave it in the S corporation. The S corp is the one that has the operations. And where'd you put the land? You put the land over here in LLC number 2. You had the exact same slip and fall, fill in the blank, employee auto accident, bad hamburger, workers defect, whatever, something falls off and hits someone on the head. Now you may have the same loss. You're personally protected, right? Because LLCs also have less formalities than corporations. So no minutes. There's things are a little bit lighter. But now look, your land is in a totally separate universe. And as a result, it's not subject to the corporate liabilities because you kept it separate. And here, a very simple owner-occupied lease agreement. You have a debt on one side, income on the other side, and it even tax-wise, it works out the same, right? So you have your S corp over here. You have your building, which is fine. Also make it an S corp or sub S, or you make it a disregarded entity, whatever. But now you have them completely separate. This is diversifying your corporate assets. And so I have a client, Vistage guy out here in California, who says, Brad, he does chemicals. He does chemicals, the cleaning things. And he says, Brad, I'm one employee accident away from losing everything. I said, David, you're right. So here's what we're going to do. We did exactly this. We pulled out his building. We pulled out the second building. We pulled out the IP. We pulled out the inventory. We pulled out the equipment. So over on the right-hand side here was all these family of assets: lease agreement building 1, lease agreement building 2, use agreement of equipment on the LLC 3, exclusive licensing agreement for the IP on LLC number 4. And if the guy that has the car accident or the employee problem happens in OpCo, he may lose OpCo, but he didn't lose any of his assets, right? You hang the shingle up the next day, you call the company a new company, and bam, you're right back in business. Because we separated the assets from the liabilities. It's simply called isolation and insulation. That's kind of just a philosophical thing to deal with. So here, now the big difference between LLCs and corporations is on the external side. So the example I gave you with the corporations is they can grab the asset and have some reverse piercing issues. That does not happen in Florida, period. So you have to be very careful though, because there is a landmark case that happened called the Olmsted. And there's two big cases in the litigation world that kind of affected single member LLCs. One is called In re Ashley Albright, which happened in Colorado, and the other one was Olmsted in Florida. And again, these two cases sent ripples through the legal community throughout the entire country. I'm not sure if you felt it, but I certainly did. And so Olmsted is just one of those cases that's in your backyard. It's a Florida case. And so the bottom line is everyone's always saying that I have an LLC, it's in Florida, so I'm protected. Yes, you're protected from an inside point of view. LLC corporation's the same. The problem here was single member LLCs. When you are the only member of the LLC, say for example, you have a property that you received on inheritance. I have rental property, right? My mom gave it to me as an inheritance. It's in my name, not my wife's name. So I have a Florida LLC in the name of Brad. It's being rented, et cetera, et cetera. Brad gets into a car accident. Question is, can they pierce my single member LLC and grab my inherited apartment building? The answer is yes. And that's exactly what Olmsted said. So if you were to put your cash inside there, you're running a business inside there, all of a sudden those protections, those Florida general ideas, we don't like reverse piercing, goes out the door, because all of a sudden there's case law that lets you reach in and grab those assets on single member. Why? What's the big deal with single member versus multi-member? The big deal is about an innocent person to protect. The whole idea about not letting somebody into your company from the outside is, let's say Heather and I are in business together. Heather, if I get into a car accident, it's not fair to you if my creditors are able to pierce the company and start fiddling around with the assets, interfering with management. You're an innocent bystander here. You're an innocent co-owner. And so the law acknowledges that. And so in LLC land, we protect the enterprise from an offending member for the benefit of an innocent member. But what if there is no innocent member? Then the whole concept of charging order goes out the window. And that was an unclear point in Florida prior to Olmsted. They thought that single member LLCs would give you internal protection and external, and Florida took care of that. Said no. Olmsted said no. And as a result, now we have deficiencies with single member LLCs. We have some solutions. You can create multi-members, putting on spouses, putting on kids, putting on other trusts, or very simply, changing jurisdiction. Rather than being a Florida LLC, why not be a Delaware LLC? Why not be a Wyoming LLC? Why not be a South Dakota LLC? Why not be a Nevada LLC or an Alaska LLC? These are states, I call them the Fab Five. These are states that specifically addressed Olmsted and In re Ashley Albright, say that we will give you single member charging order protection, notwithstanding not having an innocent member. So if we're trying to maximize the protections for our clients, and we have a situation where you're unmarried, or it's inherited separate property asset, or you want to just protect things from your spouse by keeping operations differently, fine. Just let's make sure that we put the proper force field around the asset so a creditor cannot get in by using those other states. And there's nothing wrong with you having a Delaware LLC operating in Florida. No problem with that. It's not a Florida LLC, it's a Delaware LLC. We take this wall of sticks, and we convert it to a wall of bricks, because that's what these Fab 5 jurisdictions allow us to do. You're still operating in Florida. The building is still in Florida. You're still dealing with Florida, but I give people the example, it's like Disneyland, right? It's not a California corporation. It's a Delaware corporation headquartered in Anaheim, California, right? It chose Delaware. Microsoft, Delaware company, not a Washington company, Delaware, authorized in Washington, right? So one of the benefits of being a country of 50 states is you can pick whatever state you want to govern your enterprise. So let's pick the best states for what we're trying to do, that is limiting our liability and protecting our assets. And the nice thing about charging orders, if someone's trying to go after, they cannot pierce this. But what do they get with a charging order? What they do get is any income that's distributable. But remember, you're the manager. I should make that clear. Back here, you're the member of the LLC and you're the manager. Think of it as the president of the LLC. So if they come over and they cannot get in, but they did take over your economic, they stand in your shoes as the economic interest holder, but they cannot interfere with management. I just got done telling you that. We need to protect Heather from Brad's creditors. They cannot interfere with management, but they stand in Brad's shoes to receive any economics coming out. But Heather, if I have a creditor and I'm the manager, what am I not going to do? I'm not going to make distributions, right? I still take my salary, but if I make a distribution, it doesn't go to me, it goes to my creditor. Creditor can't stop me. It can't force me to do anything, so I simply won't make a distribution. So a creditor with a charging order cannot reach the LLC assets. They cannot manage or vote the LLC. They cannot control cash flow. They cannot force a distribution. They cannot cause a liquidation. As a matter of fact, since they're in my position as the economic interest holder, what do they get? They get the tax bill. So even though I continue to operate the business and we're producing an income that was never distributed, it's called phantom income. The K1, representing the phantom income tax, goes to the party who is entitled to the income. So in LLC land, unlike corporations land, not only can they not pierce the entity, they cannot interfere with the activities, they get the tax bill. So you can see why LLCs become the basic building block, because it's such an unattractive asset for any kind of remedy. If the exclusive remedy is a charging order in these Fab 5 states, why would a creditor spend all this time, effort, and energy going after an asset that they can't grab, they can't manage, they can't liquidate, only to get a tax bill, right? So this is how we change that litigation playing field from being in a position of vulnerability to a position of strength. Like I said, and now we kind of put this together and we separate the assets out, and you kind of start seeing how this all fits together. So how do we then satisfy our $1.5 million? Okay, I already told you that our home is safe. Home's awesome. We lost our Burger King internal creditor. They gobbled up the land and they took our operations. Okay, we're out of it. Apartment building is held in trust. And how much protection does the trust offer us? Zero. So they could foreclose on our $2 million apartment building. Well, also our house, our townhouse, same thing. If it wasn't sufficient because of cost of sale, etc., they could go after the next asset. And what about the cash? Here, I would have gone after the cash first. I would have gone after the cash because if I have a creditor going after real estate, what do I have to do with the apartment and the townhouse? I have to get a sheriff. I have to levy. I have to sell it. I have cost of sale. I got to pay off. I may have to even fix it up to get a good price. I have to then pay off the banks. And only then do I get a net return. What about cash? Do I have any of those problems with cash? The answer is no. And there's no inherent ugliness to cash. Just no protections, no exemptions, just give me the cash. So we want to make sure that we protect that cash as much as possible. All right, so this is kind of how it works out. So what we then do is we start applying our asset protection tools to Hank and Wendy scenario. So what I like to say is let's create an asset protection mess using multi-entity structuring strategies. And this is exactly right. I just gave you the example with my client David out here in California. We used an LLC to hold the stock in his company. We used it to hold the real estate. We used it to hold his cash, his IP, and forget the retirement. You don't have to worry about that in Florida. So here is what it looks like. Again, we talked about the internal liabilities here, but what about we want to protect the assets also, not from the Florida law, but from the Wyoming, Delaware, Alaska, South Dakota, Nevada. We want to protect that as well. We're not worried about the liabilities. This is the internal liability. Florida's just fine for that. But we want to use a jurisdiction that protects us this way and this way. Whoops. But we have to worry again about Olmstead. These cannot be single member LLCs. They simply won't work. And there's case law to that effect. So what's the bottom line on this one? Very simple. Don't put all your eggs in one basket. All right. Getting back to the tax tail wagging legal dog. And how we deal with business assets is very similar on how we deal with personal assets. Can we put your cash somewhere? The answer is yes. What about my rental properties? Yes, they all belong in their own separate entity. And so here what we did for this is what if I put the apartment building not in their individual name, but it was held by an LLC. The townhouse wasn't in trust, but it was in an LLC. They can't get in and grab the asset. Sure, I may be negotiating a settlement, but I didn't lose the asset, right? It's a very important takeaway. And so now we're still stuck with our cash. Oh, that's a mistake. Okay, there we go. Now we have, how do we now fortify the castle? We're getting very, very intimate. This is what we use for cash. So now we're looking to use now what's called a Nevada Wealth Preservation Trust. You all may have heard of these things, Asset Protection Trust. And so I like Nevada because Nevada historically for the last 20 plus years has rated #1 on the domestic trust rankings consistently over time. And we've been using Nevada Trust for, well over a decade. Absent a Nevada Trust, the only other thing that we really have to offer is an offshore asset protection trust. And that's great too. I've done many, many, many offshore trusts. The difficulty with that just has to do with, as a result of 9/11, with the Patriot Act, it became challenging, not impossible, but it became challenging for clients to put money into offshore structures. Because now everyone assumes if you have an offshore structure, you're either a drug dealer or you're a terrorist. Why else would you have money offshore? I always try to remind people, red-blooded Americans can have money offshore too. It's okay. The question is, it has to be done correctly, and you have to make sure that you report your income to Uncle Sam. Uncle Sam doesn't care where you put his money, but just tell him where it is so he can tax you on it. That's what people are worried about. Offshore asset protection is a topic for a different discussion. So we'll stick with the Nevada structure, and this is basically what we would do with cash. We put your cash inside another protective entity, and then this entity sits inside an asset protection trust. That's what the red line is, goes from here to heaven. You cannot penetrate this thing. You are the manager of the LLC, underlying manager. You are the investment trustee. You're investing everything happening inside the gray oval. You manage that. And you're also the beneficiary of the trust, right? So you're still wearing, I'm the manager, I'm the beneficiary, but unlike a regular revocable family trust, this trust does offer you asset protection based upon how it's structured and based upon the state law that we're using. And we typically use Nevada. I've done a couple in other states, but the substantial majority of the things that I've done in Nevada, and we have to use a Nevada trustee in order to take advantage of that. I have a whole video that takes about 20 minutes just to explain how these various pieces work together. And again, if this is a conversation that we have, I'll typically be more than happy to share that with you. But this is what we would do for cash, because now all of a sudden your cash, you can still use and enjoy the cash, but guess what? The guy out here, which is you don't own the cash. The cash is owned by a trust, which is being held for your health, education, support, maintenance. You don't own it, but you control it as the manager. You control it as the investment trustee, but you don't own it. So another very important tenet of asset protection kicks in. It's called own nothing, but control everything. And that's what you're seeing on the screen here. This is a have your cake and eat it too arrangement. My client sitting out here doesn't own a damn thing. Everything is tied up inside the trust. And if they have a lawsuit against them, they're still able to use and enjoy all the money that's inside here without ever touching it. They're the beneficiary of a trust. You got a mortgage bill to pay, you send it to the trustee uses the money, they pay your mortgage. You got a car bill to pay, you send it to the trustee, they'll pay it for you. You got to pay your kids' tuition, they pay it for you. You got to pay your credit card bills you're living on, they pay it for you. You got to pay your lawyer who's defending you, they'll pay it for you. And all the while, you have this judgment over you, this abstract that you never, even though as a receiver, no money ever went to you, but you're still able to use and enjoy the money. This is how you win the waiting game. It totally changes it. And it's only available with a trust structure. An LLC by itself will not work. You gotta level it up to a trust where you put yourself on as a beneficiary of these kind of assets. And so here's the chart that I like to share. This is the 11th ranking on this. This is effective as of, this was the April 2020 version of it. And so you'll see here the states, Nevada, South Dakota, Ohio, et cetera, et cetera. And if you look here, Nevada is always, it's been number one for as long as they've been making this chart. And although South Dakota is a close second, there's a big difference right here in this middle column. And if we read it together, it says spousal or child support exception creditor. So this is a U.S. jurisprudence thing. This isn't an issue in offshore. Offshore, you do what you want with your money. They don't care. But the U.S. says, we'll let you, in these top 10 or so jurisdictions, we'll let you create an asset protection trust. But there's two people who will always have the keys to the back door. They are your spouse in a divorce, and they are your kids in a child support. It's called your car accident guy can't get it. Maybe the government can't get it, but these two guys, they can get it. Every state has the exception creditor except Nevada. And Nevada says, it's your money, it's your trust. You want to deal with it this way, this is how you deal with it. And so why is that important? I use this besides just for creditor protection. How do I use this specifically for marital assets? Go back to the inheritance. If I receive $5 million as an inheritance, who knows what's going to happen with my marriage? God forbid anything were to happen to it. But you got that statistic that goes out there, 50% end in divorce, whatever. All of a sudden now you may be in a spousal dispute about the assets. In my state, community property, your guys' equitable division of assets you held together, not separate property. And especially now if it's put inside a separate property entity that respects separate property, even from divorced spouses. I use it for inheritances. I use it for windfalls. I use it for people that are about to get married as a premarital tool. You can tell me all you want about premarital agreements and postmarital agreements and whatever. All, in my opinion, that is an evidence of an intent to keep things separate. But how does it play out in court? Your Honor, he told me to quit my job. He'll take care of me. Don't improve yourself in the marketplace. Everything I have, honey, is yours, right? Yeah, I call that the pillow talk. So you may pull up this evidence. This is my evidence of intent, but in reality, your behaviors could wind up unwinding that. There's no teeth to that. So here, this puts the teeth in it. I also use it for business succession. The good son, that's me. I'm the only son. I'm the good son. So my dad, Brad, you can have X amount of my company assets. I love you. You're the good son. My daughter-in-law, not so much. I don't want my company to ever wind up in the hands of my daughter-in-law because it's my company. And if you have a crummy divorce lawyer or you have no backbone, you just give it to her in settlement. Next thing you know, my father is now in business with his ex-daughter-in-law. And we don't want that to happen. So here again, as part of a business succession tool, we take the 10, 15, 20% and we give to the good son, we give to the good daughter inside an asset protection trust because we never have to worry about the spousal support issues, the child support issues, the commingling of those assets, the pillow talk issues. And we say, hey, as a condition of receiving that 10%, this is what you got to do. Right? You can keep your asses with your wife all you want. I don't care. But when it comes to my business, if you want a part of my business, this is a condition precedent that we set this up. Very, very powerful from that perspective as well. All right, so it's a good planning tool there too. So here, had we used a Nevada Asset Protection Trust, now we would have our safe $1.45 million asset. All right, so I think I messed this up again. I've got to fix the slides. So in the last 10 or 15 minutes that we have together, let me kind of show you how I put this all together. So I kind of gave you these various tools, but how does it all fit together? Let me see if I can share with you this. Okay, this is a map program that I use for all of my clients. And here's Hank and Wendy. This is kind of, I'm a visual learner. I plan this stuff out. So this is how every one of my clients works with me. If you work and we do a consult together, you give me enough information to put this together on the assessment from Paul, I will put this together. This is kind of how I keep it keep it in check in my brain. And it also becomes the checklist that my office uses for implementing such a plan. So here we would have our non-probate assets. These are assets that go according to beneficiary designation. It doesn't matter what your estate plan says or will says, it goes according to the beneficiary designation. So our life insurance, we have this wonderful Florida exemption that applies. So from an asset protection point of view, it's safe. I'm not addressing estate tax issues here. I'm just addressing purely the character of the asset. Qualified retirement plans, both federal and Florida exemptions apply. So here again, great, nothing to worry about. From an estate planning point of view, we look to do an estate plan, not only for our clients, but I'm also worried about what about their kids. Estate planning, you're talking about typically multiple generations. So I'm going to show you tools in a moment that solves Hank and Wendy's problem, but what about the kids, right? Again, love my son, not my daughter-in-law. Love my daughter-in-law, don't like my son. Like my daughter-in-law, hate my son. I get all kinds of situations like that. The bottom line is like this. There are ways that we can create protective tools from an inheritance right into your estate plan for your kids' benefit. Take the asset protection philosophy and apply it over to the next generation. Create a lifetime asset protection trust for the benefit of your children. What if your kids get divorced or have overbearing spouses? How do you protect the inheritance from those overbearing pressures? If your kids have drug, alcohol, gambling, negative influences, special needs issues, how do you protect and preserve the inheritance from all those forces, including governmental entities for special needs requirements so they can still qualify for Medicaid and Medi-Cal and Social Security, et cetera, et cetera. And also multi-generational. If you have a large enough estate, you may want to say, like my father, Brad, I'm going to give you $5 million. But when you pass away, that's Brad, when you pass away, I want my money to go down to my 4 grandkids. I don't want you, Brad, intercepting $5 million, my $5 million, giving it to your wife, who then remarries Fabio and off with his 6 deadbeat kids, right? So we were worried about the estate being intercepted. So this way you, through the use of multi-generational provisions, can say, for my child, protected, divorce protected, and when my child passes away, I say it goes down to the next generation. You're controlling that. So this all happens inside an estate plan that doesn't just have a outright distribution or distribute at 25, 30, and 35, or distribute at 40 and 50. There's no thought behind that. It's just a distributionary tool, and you're losing an asset protection opportunity as well. So that's just that one. Tax structure, and these are revocable trusts, so no taxes. So here is where the magic is in the funding side. Here again, Florida, wonderful homestead exemption. So nothing fancy to do. Personal property, Florida's got some good exemptions. We keep a family budget of typically about 3 months of expenses. Remember, I don't want Hank and Wendy's $1.4 million in their trust name. There's no protection. So here we have the family budget, maybe keep 50 grand inside there. Business assets, here we have Widget Co. It does the corporation. I put it in this spiny red because this is a pure liability, kind of like my client David with the chemicals and whatnot. Pure liability, operating company. Where did I put his assets? Widget Commercial Holdings. So inside here now, there's his commercial building, right? There's the commercial building. If he owns it with Hank and Wendy or owns it by himself, again, watch out for homestead issues. Here's the commercial building. That's now being owner occupied with a lease agreement going back and forth. What about the equipment? All right, so you kind of break this one out. Equipment holdings, trucks, equipment, inventory, IP, whatever it is. You kind of, so now Widget Co., the business now comprises of these three companies, right? You got the operations, you got the real estate, and you got equipment, or however many you want. This is kind of an idea of how, if you had noticed, this is all sitting inside the family trust for probate avoidance and for distributionary purposes, not asset protection. Asset protection is happening at this level, not the trust level. The rental properties that we spoke about, single family homes. Here we go. I'm just going to open up one of these because they're both the exact same. Here, I'm actually doing something a little different. Here, this is Hank's. Hank received it. Single member LLC. Problem, right? Because it was an inheritance. Olmsted, I cannot use Florida. So what am I using? I'm using Wyoming. Authorized in Florida. Wyoming is giving me the protections where they can't get past the purple line here, that they can't penetrate that LLC. Wyoming, because it's single member. But I also did something else here. I'm using a privacy-based entity because my client says, I don't want the tenants knowing where I live. I don't want them showing up at 3 in the morning saying, hey, Brad, fix my toilets. Yeah, so we're using a privacy component where they have all the asset protection of the Wyoming structure, all the limited liability, and they also go incognito from a recorder's level and from a statutory level at the Wyoming level. We have privacy tools that a lot of my clients use as well. Again, another very beginning part of asset protection. If you look like a pauper, you're not worth suing, then that again deters litigation. And then getting down to our asset protection tool, our trust. There we go. We got Nevada. Hank and Wendy are our creators. Hank and Wendy are investment trustees. We're using a Nevada-based trust company for our alliance, for our administration and benefits. Here's our chart once again. And now what do we stick inside here? We stuck, in this case, there's Hank and Wendy's $1.45 million of cash inside there. Nevada, authorized in Florida. They're banking in Florida, they're managing in Florida, but it's a Nevada asset. Nevada asset held by a Nevada trust. That works incredible. And we also stuck Widget Co. IP because that's the biggest asset that the client has. There's no liability with the IP, so it's just assets. I want to make sure that all those monies that come off of OpCo for the IP pour into the asset protection structure, because this is not just a wall of sticks, not even a wall of bricks. This is like a fortress with force fields and electrified fences and drones flying around it with missiles and whatever. This is a very powerful tool absent going offshore. No one's going to be able to get past this so long as you set it up in advance. Again, you have all the fraudulent transfer issues, all the fraudulent conveyance issues and conversion issues. You got to have this stuff set up in advance. All right, let's kind of get back over here. And lastly, in the last couple of minutes here, talk about ethics. So this is an important thing because as I give talks over time, people come back and say, gee whiz, Brad, it's not ethical what you're doing. Letting people put their assets behind these brick walls and not letting people come after and take it from them. I say, listen, we are simply fighting fire with fire, right? If the plaintiff's lawyer is using a legal system to steal my money, my hard-earned money from me, I'm going to use that exact same legal system to protect my assets, because if it was an accident, you don't go through life with the intent of hurting people. If you hurt somebody and you want to make them whole, you have the option to do so. You have insurance for that reason. If you want to come out of pocket as part of your settlement to make someone whole, to indemnify them, that's your option. But no one's going to steal or force it from you. That's the main difference. And it's not about hiding assets whatsoever. When you present somebody with your financial statement, when the time is right, strategically disclosed, they then realize what they're up against. That financial statement itself becomes a settlement tool. So it's not about hiding assets. If anyone tells you I want to hide assets, run. That's wrong. Because if you wind up not disclosing something under penalty of perjury, and then they go online and say, hey, listen, I got a question. Brad, do I have to disclose the $500,000 of gold bullion that I have buried in the Folgers coffee can in the backyard? I say, well, of course. Well, how are they going to know? I said, well, how did you buy it? Well, I bought it on my American Express card because I wanted the points. I said, great. So if you go up there and say, I don't have any gold, and then they show up on the board, see that 500,000 perjury, right? Talk about leverage, throwing you in jail for wearing orange pajamas for committing perjury. That's leverage against you, right? You don't need to hide assets. You just put them in the right spot that's protected in advance. And you will carry adequate insurance. That's the whole point. I have enough insurance for what my risks are. And it's not about having too much insurance. It's not about having too little insurance. You want to have the right amount for your net worth and or for what you do. And understand that there's a trickle down effect here. That if you have an accident, I'm sure just like every one of you, I wake up every morning, I try to do the best I can for my family, for my customers, for my clients, for my employees, for my vendors. I try my best to do the best I possibly can. But why did God put erasers on the ends of pencils? Because we make mistakes, right? There's car accidents, malpractice issues. I have a large organization, something somewhere a driver. I don't know. All I know is that I don't want that accident to put me and my family on the street. I don't want that to put my family, my employees on the street. Right now, with a large unemployment, you got 30 or 40 million people unemployed. My people, thankfully, are gainfully employed, and I don't want them to be unemployed. I'm only successful because they let me be successful. I need to make sure that my employees are protected to the best that I can. And so protecting my company and my assets also protects my employees and vendors. All of us vendors are extending credit to us. Everyone's trying to say, I'll take half now, I'll do whatever I can. I need to stay in business. I need cash flow. And if all of a sudden you're completely wiped out and you have a large accounts payable to all of your vendors out there that were relying on your ability to pay them, now they're in a tight spot too. So I think it's actually irresponsible and unethical not to take some steps to protect everything that you've worked for and people that are relying on your wealth. Okay, that's kind of my piece on that. So finally, in conclusion, right, asset protection assessment. We need to know, and do me a favor, I take a lot of time in working with you guys on these assessments. I put those maps together, but it's only as good as they say, garbage in, garbage out. Give me the information and we can have a very good, productive conversation about that. So take advantage of that assessment and let's have a good conversation. You could be sued at any time by anybody and for any reason. That's how you get rich in this country, right? You either sue someone or you inherit money. That's how it works. And now with this COVID invisible boogeyman thing, it adds a whole nother level of potential liabilities and being sued. So I call it the lawsuit lottery. No after the fact transfers. We talked about that multiple times already. Not all credits are created equally. What we do for a car accident is different against divorces, which is different against guarantees and banks. And we have to know what tool we need is appropriate for who the potential creditor is. We need to know these things. We're all about promoting settlement. Insurance companies never lose money, so we want to take a look at those and have a quick little evaluation of your insurance policies. And if you see holes in them, plug it, get an endorsement, get a rider. If you do have that bad dog, get a rider for the bad dog. Florida, you got to take advantage of your exemptions. These are wonderful for you guys to maximize those. If you don't, like I said, you really are losing out. That's a California thing. And don't put all your eggs in one basket. You need to diversify. Okay, so like I said, don't let the tax tail wag the legal dog. This is important stuff that in order for it to work properly, you need to be able to make it difficult, time-consuming, unattractive, and expensive for someone to go after your assets. That's how you're in a position of strength to negotiating settlements. And poverty is power. As I mentioned early on with the very first example I gave you with I can't move the building, right? If you have that $1 million building, you can't move it. You can't stick it offshore. You can't, but what you can do is you can suck out the equity. When someone sues the building, they don't want the building. They want the value that building represents. So if we've sucked out all the equity, and now if you're sitting here on $1 million in cash, you've actually did the creditor a favor. Gee, thanks, Brad. You turned my illiquid asset into cash. That's only halfway. Now you got to take the cash and put it someplace safe, like your Nevada Asset Protection Trust. So that's how you use debt to your advantage. Encumber your equipment, encumber your buildings, encumber your ARs, et cetera, et cetera. And remember that a revocable living trust is not an asset protection tool, all right? And there's no silver bullet. It's just like everyone changes over time. Your plan changes over time. The tools that we have evolve over time based upon case law, et cetera, et cetera. So, but you need to know by having a planning, you can sleep comfortably at night knowing that you have some kind of proper protection and you can make it to the end. And when Disney opens up again, we can all live happily ever after, right? Okay, so that's basically it, the end. I know that I think Paul did send on the comments over here that consultation request form. That's what this is. So Heather, if you're good, we'll take everybody off mute and we'll open it up for questions.
Yep, that's perfect.
Unmute, unmute, unmute.
Hey, Brad, that was a great presentation. Thanks.
Great, thank you. I'm not quite sure how to, there we go. That was unmute, unmute and. Okay.
Folks may have to unmute themselves.
Yeah, I think so. I think so, yeah.
Well, Brad, I've got a quick question for you.
Yes, please. Yes.
This is Taylor. I've got two houses paid off. One's homestead exempt, one's our other house. Can a married man and woman have two homestead exemptions in the state of Florida?
The answer is no. Homestead only applies to your primary residence. So typically you'd have a homestead for your primary residence because and to be your primary domicile. So even though you say, well, I consider both of them as my residence. Well, which one do you use on your driver's license? Which one do you use for voting? Which district do your kids go to school? There are certain badges of domicile. That one would be determined. That one would be your homestead. The other property, although it could be a second residence, we have different tools for that. That will give it protection, but it won't be to the level of a Florida homestead.
Okay. Oh, because I was reading about the family unit idea in Florida, and I was wondering if you could use that to establish two homesteads.
Let me take a look into that, but that's basically like I said, one homestead, and then but you can have multiple residences, right, in different states. Yeah. Okay, great. And thank you for the question. Any other questions? I know that it was a rapid fire 90 minutes, so.
This is John Michaelish. I know I saw in your entity map, one of the things that you did is you had placed corporate assets and dropped them off into an entity that owned assets. I imagine that makes a lot of sense when you have significant assets in play in the operation of your corporation or LLC or an LLC structure. I imagine the idea or concept behind that probably isn't that much different than owning real estate, where you drop the real estate inside of a separate LLC and just lease it back to the entity for the purpose of just protecting an asset and providing, that's even in this case, another source of revenue that sits off to the side in a protected form.
Right. Well, yeah. So it all depends on who the lessee is, right? So if you're talking like an owner occupied, then the answer would be yes. If it's a personal holding where you're just getting rents coming off of it, those rents can accumulate inside the entity. We could even, if I'm following your point, where you can actually even use it as part of a management company, and you can create your own like retirement plan and some other types of benefits that can kind of spin off of that.
I was thinking more like and maybe I misread what you had on there, but let's say we have significant machinery employed in the operation of business. Let's say other things, they tend to be somewhat expensive, lots of so the ownership of those vehicles would sit inside of an entity, much like the ownership of the land.
Exactly.
Right? So
yes, that's correct. Yes.
Leasing back the use of those.
That's right.
Like rate back to the corporate entity.
That's exactly right. And that's important. And I give people the example, just the use of the equipment and machinery, for example. Like I had some work done in my yard, and I have a contractor, and the guy shows up with like this like little steam shovel thing. He's digging up the ground. I say, "Hey, Randall, is that yours?" He says, "No, it's not mine. I rented it from the equipment manage co over there." And he has an agreement to use it for a certain time period, and he paid a certain amount of money, and he has some insurance, etc. But that's exactly what I do with my clients. You can create your own equipment leasing company, right? Where your OpCo can lease those assets back, right? It protects the asset, it limits your liability, and it works out. It works great. And even better, if you happen to have someone, third party, not you, that also may want to lease it for a particular event. Maybe they want to use a truck, or they want to and you have now you've actually gave a lot of what do you call it? What do you call it? The benefit to that, because it's pure leasing, not just to you, but also to third parties. Use that for people that have airplanes, they have boats, not a charter company, but they may let someone borrow it. It kind of gives a lot of credibility to that leasing company. But that works absolutely just like you said, and it works out tax wise also.
Those in the GAAP standard, that would roll into what's called probably an SPC, these segregated portfolio companies, which wind up being consolidated up to your financial for.
That's right. All right. So they all kind of, I would say, all kind of pyramids back up to the top, and that top one works out. Asset income on one side, liability on the other. It should be a net zero.
Gotcha. That shouldn't really matter for liability. All right. The leases is for private companies isn't so bad right now, but the change in GAAP on the leasing side is significant accounting.
Right.
If we were to lease all of our assets back, it would be a big accounting load.
Okay, so alternatively, alternatively, this all goes down to feasibility, right? Because there's always more than one way to accomplish the goal. So if you can't put it into a separate entity, is there a way that we could again use debt to encumber it, right? So now the asset doesn't have the value, right? So it's an encumbrance thing. So that may be an option. Okay. Again,
when you say that, is that like creating a lending company where we just?
No, there actually are. We have a lot of lenders that will basically lend off of the fair market value of assets. So so they'll use the asset as collateral for basically an instrument, a debt instrument. And so they basically will suck all the equity out of it as an equity stripping tool. That's just one of the tools that's available. Again, a lot of the stuff goes down to feasibility. So when we work with, especially with corporate assets, we try to get the CPA, the CFO, and of course you, the CEO, all kind of brainstorming. Okay, we know what we want to accomplish. The question is, how do we get there? We know what the outcome is. What method do we use to get there? And it's got to work out, right? You can't be so tunnel visioned on the asset protection component that it, like you said, it kills your bottom line. So you got to find a way that works. And there are multiple ways, separate entities, there's equity stripping, there could be some collateralization, other things that can be done. Okay. So it's a good and tough question.
Yeah.
Yep. Okay. Heather, how about yourself? Anything?
No, I really enjoyed the presentation. I mean, totally different viewpoint, looking at it from a different seat than obviously everyone else on the call is. But yeah, no, I thought you did great, Brad. I mean,
okay, great.
Yeah, I mean, I hope it was valuable to everybody on the call. I think it's coming at a really good time, and I think there was a lot of good information.
Oh, great. Well, thank you. Thank you for the opportunity.
I have one more question.
Sure.
We have we operate in about 9 states. Every state set up as its own LLC, which is owned by a holding company, then owned by an ownership entity called Two Blade Enterprises. In this case, I used to have a cash account inside each one of the entities, and that cash account did business, would raise bills and collect funds in each one of the individual entities. I've since consolidated that to be, just for operational reasons, to be one cash account where my Two Blade Enterprises account now writes the checks for all of the entities, and then I pass intercompany transactions back and forth with those entities.
Yep.
The case that I just created, where I have one collection entry and one collection account and one remittance account, did I just pierce my own corporate veil, so to say, and weaken my corporate structure for the purposes of liability? So if I have a slip fall in one of those entities, is this now going to be a track back saying, hey, this isn't really
right? I got it. Here's okay. I totally get it. You should have an agreement between the companies. That's all. An agreement. So basically you have your parent company, or whichever your
so to say.
What's that?
Like a service agreement between
exactly. You're basically, this company up top is a management agreement that's authorized to collect and pay expenses on behalf of this. It's basically a management company, right? Many times we put the C-suite of officers up in a managed co, and then they're managing all the various, kind of like a franchise model, all the various subsidiaries down below. And so, but you got to have the paperwork. Otherwise, what you're describing is, yes, you've reconnected through the money trail what you may have initially separated. And so you gotta just have the contract, so you can say, no, it is separate. We're hired. You got to charge a fee for this, right? You got to have a little bit of a fee on it, so you actually are engaged in management services. So you have one ledgered account for all the underlying entities, however it's structured, but that's the idea.
Gotcha. No, that's helpful. Thank you.
Got to be papered. Yeah, it's got to be papered. Because what you're talking about is exactly right. We call it the enterprise theory. Your Honor, this is all just one big enterprise. Screw all this different entity stuff. No, that's not the answer. The answer is that it's respected to the extent that you're operating it correctly, and the money trail is the biggest what do you call it, telltale sign, right? But if the money trail is authorized, you've agreed that, and everything else follows correctly. It's the earning a fee for it. It's commercially viable, and you have it all being done legitly. You're fine. You kept this. A company can have more than one entity. It's okay. Right?
No, that's perfect.
Good.
All right. Thank you.
Great. Okay, so Heather, what I'll do is when this is done, I'll send you the recording over, and I'll send you the deliverable of this article I recommend. And I think Paul already sent over the CC. So hopefully we'll hear back from you with some comments, and hopefully we'll have a chance to speak with your attendees.
Great. Thank you so much, Brad.
You're very welcome. Thank you. Thank you.
All right. Bye, everybody.
Bye-bye.
Bye.